Good afternoon and welcome to the South Carolina Public Service Commission and our weekly commission business meeting. Today is September 11th, 2025. Here in the hearing room is Commissioner Belser, Commissioner Britt, Commissioner Caston, Commissioner Carolee Williams, and I am Delton Powers. Vice Chair Williams is on military leave. Commissioner Thomas is on annual leave, and neither will participate in today's matters. Before we begin, could we take a moment of silence and particularly remember the 9/11 victims? Thank you very much. Mr. Scarborough, if you would, please address our docket.
Good afternoon, Chair Powers and Commissioners. First order of business is to set the date of the next business meeting. Staff recommends that the next regularly scheduled commission business meeting be set for Thursday, September 18th, 2025 at 1 o'clock p.m.
The next business meeting will be September 18th at 1 o'clock.
Thank you, sir. Today we have 14 items on the utilities agenda and just 4 items on the transportation agenda. Item number 1 is in docket number 2025-77C. This is a request for approval of the first negotiated amendment to the interconnection agreement between Bell South Telecommunications, LLC and Wide Voice, LLC.
As to item number 1, is there a motion?
Mr. Chairman,
Commissioner Britt.
I move that the commission approve the First Amendment to the interconnection agreement between Bell South Telecommunications, LLC and Wide Voice, LLC, and executed by the parties on August the 11th, 2025.
Thank you, Commissioner Britt. Having heard the motion by Commissioner Britt, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 2 is in docket number 1985-150C. This is a request from ATM Carolina Incorporated to cancel its payphone service provider certification, which the commission granted in orders number 1987-1059 and 2013-76.
As to item number 2, is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. On August 27th, 2025, ATM Carolinas Incorporated notified the Commission that the company no longer owns, operates, services, or maintains pay telephones or any other communication devices in South Carolina. All of the company's equipment has been removed from public access. I move that the Commission grant the request of ATM Carolinas Incorporated to cancel the company's payphone service provider certificate and all authority provided to the ATM Carolinas Incorporated by the Commission orders number 1987-1059 and 2013-76. So moved.
Thank you, Commissioner Caston. Having heard the motion, is any further discussion? It would be nice to have an old payphone and a pinball machine, but I don't have either one. Since there's no discussion, we'll move to a vote. All those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 3 appears in docket number 2025-14C. This item involves a request from the Office of Regulatory Staff for certification to the Federal Communications Commission and the Universal Service Administrative Company of the use of the Universal Service Funds by certain eligible telecommunication carriers.
As to item number 3, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. Pursuant to South Carolina Code Annotated Regs 103-690.1.b, the Office of Regulatory Staff notified the Commission on August 18th, 2025 regarding the compliance of eligible telecommunication carriers, also known as ETCs, in 2024 receiving federal low-income and high-cost universal service support. Other ETCs, which include incumbent LECs and affiliates, and carriers receiving RDOF, which I think is Rural Development, and then something funds. Support filed requests and affidavits concerning the use of federal high-cost support pursuant to 47 CFR 54.314 and Telecommunications Act Section 254E. Federal Communications Commission, CC docket number 96-45. in 2024. I move that the commission grant the request from the commission designated ETCs for certification of federal high-cost universal service funds under all applicable laws and direct staff to file the certification letter with the Federal Communications Commission and the Universal Service Administrative Company. Additionally, I move that the commission further direct commission staff to add any other carriers filing with the commission a request and affidavit concerning the use of federal high-cost universal support. The commission's certification letter to the Federal Communications Commission at the FCC and Universal Service Administrative Company, USAC, must reference Federal Communications Commission CC docket number 96-45. A list of those carriers shall be attached to this directive order as Exhibit A. And Mr. Chair, RDOF stands for Rural Digital Opportunity Fund.
Thank you very much, Commissioner Williams. Having heard the motion by Commissioner Williams, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 4 is in docket number 2025-233G. This is a request from Dominion Energy South Carolina Incorporated for waiver of notice and hearing of the company's annual update on its natural gas energy efficiency programs and a petition to update its gas demand-side management rider.
As to item number 4, is there a motion?
Chair Powers,
Commissioner Caston.
may I ask if this item could be carried over until next Thursday, September 18th, just to clarify a couple of things?
All right, so then we'll carry that matter over. Is there any objection to that? We will vote then. All those in favor signify by saying aye.
Aye.
Aye. Those opposed by no, the ayes have it. The matter will be set on the 18th.
Item number 5 is in docket number 2025-248WS. This is a request from Kiowa Island Utility Incorporated for expedited approval of its minimum filing requirements templates.
As to item number 5, is there a motion?
Chair Powers,
Commissioner Caston.
I move that the commission approve the minimum filing requirements schedule templates filed by Kiowa Island Utility Incorporated on August 14th, 2025, and together with amended schedule templates A-3 and A-12 that were revised and filed with the commission on September 9th, 2025.
Thank you, Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 6 is in docket number 2025-211E. This is a motion from Duke Energy Progress, LLC, to dismiss Ms. Bess's complaint, a request to stay all testimony deadlines, and a request for confidential treatment.
As to item number 6, is there a motion?
Mr. Chairman,
Commissioner Brett.
I move the commission grant Duke Energy Progress LLC's motion to dismiss on the grounds that the complaint fails to allege any violation of an applicable statute or regulation with respect to Duke Energy Progress's handling of the complainant's account or service. The motion to dismiss is also granted on the grounds that the complainant has not articulated a claim upon which the commission can grant relief. There is no need to address the request to stay all testimony deadlines or the request to hold the hearing in abeyance, as granting the motion to dismiss renders these two requests moot. The commission also grants Duke Energy Progress's request for confidential treatment of its motion to dismiss, request to stay all testimony deadlines, and request to hold the hearings in abeyance. The commission grants the request for confidential treatment pursuant to South Carolina Code Annotated Regs 103-804S and the Freedom of Information Act, South Carolina Code Annotated Sections 30-4-10 through Section 30-4-165 due to the motion containing customer-specific account information in order to protect this information from public discourse. Finally, the complainant, Terrell Shinette Bess, asserted that no water to the residents had been disconnected, that the water to the residents had been disconnected, and that the complainant suspects people are stealing and using the complainant's water for which the complainant is being overbilled. That complainant requested the meter be read, but nothing was done, and that the quality of the water is horrible with a funny taste. Complainant listed the water provider as the City of Darlington. Unfortunately, as provided by South Carolina Code annotated Section 58-5-30, the Commission does not have the power to interfere with public utilities owned and operated by or on behalf of any municipality or its agencies. Any concerns with the water service provided by the City of Darlington should be addressed to the City of Darlington, South Carolina. So moved.
Thank you, Commissioner Brett. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. Motion carries.
Item number 7 is in docket number 2025-173E. This involves a petition to intervene in this docket from Mr. Michael Reagan Jr. and a letter from Dominion Energy South Carolina Incorporated in opposition to Mr. Reagan's petition.
As to item number 7, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the Commission grant the petition to intervene of Thomas Michael Reagan, Jr. The petitioner has complied with South Carolina Code Annotated Regs 103-825A3. Mr. Reagan has asserted that he is a residential taxpayer served by Dominion Energy South Carolina within the Dominion Energy South Carolina territory, a class from which recovery of expenses related to the proposed pilot program would be made. Further, Mr. Reagan identifies and asserts his position both with regard to the cost estimate made by Dominion Energy for the pilot program and his objection to the request to approve the pilot program without a hearing. In its objection to Mr. Reagan's petition to intervene, Dominion Energy asserts that it is redundant to allow Mr. Reagan to intervene since the public interest is represented by the Office of Regulatory Staff, and that it is unnecessary to allow Mr. Reagan's intervention because the matter should be decided without a hearing. I move that the Commission specifically find that ORS's statutory charter to represent the public interest, where a finding of public interest is at issue, does not preclude the ability of individual interveners with specific interest in the matter before the Commission. Further, I move that the Commission find that judicial economy, which is generally served when deciding a matter without a full hearing, does not give rise itself to a reason for disallowing intervention of an interested party that otherwise possesses standing. Notwithstanding granting the intervention of Mr. Reagan, he will be limited to representing only the interest he personally possesses. In other words, the petitioner may not represent a category of ratepayers as a collective. Rather, he may represent his personal interest. I so move.
Thank you, Commissioner Williams. Having heard the motion, is there any further discussion?
Mr. Chairman, will Commissioner entertain a question?
Yes.
I may have heard incorrectly, or I may have processed it incorrectly, but I thought I heard you say that the petitioner asserted he was a residential taxpayer, and I just was curious if you meant ratepayer versus taxpayer.
I'm sure I meant ratepayer.
Okay,
Thank
I'm
you
sorry
for the clarification.
Thank you.
Thank you, Commissioner Belcher. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 8 also is in docket number 2025-173E. This is a request from Dominion Energy South Carolina Incorporated for approval of its demand-side management program for income-qualified, high-use residential customers without a hearing.
As to item number 8, is there a motion?
Mr. Chairman,
Commissioner Belcher.
I move that the Commission deny the request of Dominion Energy South Carolina Incorporated, asking that the Commission waive the requirement of a hearing in this matter concerning the approval of the company's proposed pilot demand-side management program for income-qualified high-use residential customers. I further move the Commission direct the Chief Clerk to schedule a hearing in this matter as soon as possible.
Thank you, Commissioner Belcher. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 9 is in docket number 2025-154E. This item involves motion for admission pro hoc vici from Matthew Robert Vondrasek, Esquire, Michael A. Rivera, Esquire, Thomas A. Jernigan, Esquire, and Leslie Newton, Esquire, on behalf of the United States Department of Defense and all other federal executive agencies.
Is there a motion on number 9?
Chair Powers,
Commissioner Caston.
I move that the Commission grant the motions of the United States Department of Defense and all other federal executive agencies for admission pro hoc vici of Matthew Robert Vandrasic, Esquire, Michael A. Rivera, Esquire, Thomas A. Jernigan, Esquire, and Leslie Newton, Esquire. So moved.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 10 appears in docket number 2025-224E. This is an application from Dominion Energy South Carolina Incorporated for authority to issue and sell first mortgage bonds not to exceed $1.7 billion in aggregate principal amount.
Item number 10, is there a motion?
Mr. Chairman,
Commissioner Belser.
thank you. I move that the Commission authorize Dominion Energy South Carolina Incorporated to issue and sell from time to time first mortgage bonds not to exceed $1.7 billion aggregate principal amount in accordance with South Carolina Code Annotated Section 58-27-1710 and South Carolina Code Annotated Regulations 103-823.1. The net proceeds from the sale of the new bonds, together with other funds of Dominion, will be used for general corporate purposes, including the financing of Dominion's construction program, nuclear fuel expenditures, the reduction of short-term indebtedness, and the refinancing of securities. No party shall be prohibited from addressing the reasonableness of these costs in a subsequent general rate case or other proceeding. So moved.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 11 is in docket number 2005-83A. This item involves pre-application meetings required by South Carolina Code Annotated Section 58-37-120.
Do I hear a motion?
Mr. Chairman,
Commissioner Belser.
Act 41 of 2025, the South Carolina Energy Security Act, added a new article, Article 3, to Title 58, Chapter 37. This new article in the code addresses energy infrastructure projects and provides a deadline of no later than 6 months after an application is received by the agency, by which an agency must review and issue a decision on the application. Newly enacted South Carolina Code Annotated Section 58-37-120B states that a permit applicant for an energy infrastructure project shall not submit an application for the project prior to conducting a pre-application meeting with the agency to establish milestones within the 6-month review period. To aid in the administration of dockets and hearings at the Commission and in compliance with the South Carolina Energy Security Act and the new deadlines set forth in Title 58, Chapter 37, Article 3, I move that the Commission require any person, which under the article is defined as an individual, corporation, association, partnership, trust, agency, or the state of South Carolina, to contact the clerk's office in writing to schedule the pre-application meeting before an application is filed with the Commission. So as not to delay the convening of the pre-application meeting, I move that the Commission instruct the Chief Clerk or her designee to conduct the pre-application meeting required in South Carolina Code Annotated Section 58-37-120B and to schedule the meeting as soon as practical after a request for a pre-application meeting is received. In scheduling the pre-application meeting, the date and time for the pre-application meeting also needs to be coordinated with the Office of Regulatory Staff to ensure ORS has someone available to participate in the meeting. In addition, the pre-application meeting may be scheduled as an in-person meeting, a virtual meeting via WebEx, Zoom, or other suitable platform, or a telephonic meeting via a conference call. Finally, I move that the Commission direct the Chief Clerk and the Commission staff to reject any application meeting the criteria of an application pursuant to Title 58-37, Article 3, pertaining to energy infrastructure projects, where the pre-application meeting required by South Carolina Code Annotated Section 58-37-120B has not been held before the filing of the application. So move.
Thank you, Commissioner Belser. Having heard the motion, is any further discussion?
Mr. Chairman, if I might,
Commissioner Belser.
just a couple of points. I think I've requested in this motion that the request for the pre-application meeting be in writing. And the reason for that is it can either be a letter or it can be an email. But I just think there needs to be a record of the request. I think that protects the commission. It protects the party asking for the pre-application meeting. I think that this meeting is required by statute to ensure that that the schedule can be looked at to make sure that there's not a conflict with a hearing or other matter already scheduled, and to ensure that there is sufficient time for a hearing. And finally, I do ask that the Office of Regulatory Staff be included in the coordination of the meeting, because ORS is automatically a party to all proceedings before the PSC unless they opt out, and that wouldn't occur until later if they did. And so I think that they need to be noticed of any pre-application meeting to avoid any potential ex parte. Even though scheduling is an exemption, it's just better to have them on as well. So that doesn't preclude anybody asking for a pre-application meeting to meet with ORS at a different time, because I'm sure they'll have to meet with them as well. But in our situation, I think that ORS needs to be involved in any meeting with our staff. So that's just some explanation of why I've moved as I've moved. Thank you.
Thank you, Commissioner Belser. And with the deadlines and the schedules that we do have already, that certainly are good points. Is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 12 appears in docket number 2005-83A as well. This item involves a staff request that the phrase "like facility determination" be included in the captions of pleadings filed with the Commission.
As to item number 12, is there a motion?
Mr. Chairman,
Commissioner Britt.
I move that the Commission establish a requirement whereby any application, including but not limited to an application for certificate of environmental compatibility and public convenience and necessity, that includes a request for a, quote, "like facility" determination pursuant to South Carolina Code Annotated Section 58-33-1101, must specifically note the request for a like facility determination in the caption of the application.
Thank you, Commissioner Britt. Having heard the motion by Commissioner Britt, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item number 13 is in docket number 2025-247E. This is a proposed procedural schedule for this docket from Duke Energy Carolinas LLC and Duke Energy Progress LLC.
As to item number 13, is there a motion?
Mr. Chairman,
Commissioner Caston.
Britt.
I'm sorry, Commissioner Britt.
We do sound alike. On August 13th, 2025, Duke Energy Carolinas LLC and Duke Energy Progress LLC jointly notified the Commission of their intent to file an application of their 2024 competitive procurement of solar and co-located storage with the results of associated procurement activity application on or around September 30th, 2025, pursuant to South Carolina Code Annotated 58-41-20G. The Duke companies state that the 2024 competitive procurement of solar and co-located storage is a balancing authority area-wide program that was open to bidders throughout the company's service territories in South Carolina and North Carolina, and the resources procured through this program are intended to serve customers in both states. Duke's letters dated August 13th, 25, page 1. The Duke companies further assert that the like companies' previous CPRE programs, the 2024 CPRE program, follows the company's commission-approved framework of best practices to develop and implement the procurement. While the Duke companies proposed some dates for a proposed schedule of the joint application through a comment proceeding, there are some items, like reserving a date for possible hearings and establishing a discovery schedule, that need to be addressed with all parties. For these reasons, I move that the Commission direct Commission staff to hold a conference with all parties of record for the purpose of establishing a procedural schedule for this docket, including a discovery schedule. I note that there was no objection from the Office of Regulatory Staff concerning the proposed scheduled dates or to the Commission holding the review through comments as requested by Duke Energy Carolinas LLC and Duke Energy Progress LLC. So moved.
Thank you, Commissioner Brett. Having heard the motion by Commissioner Brett, is there any further discussion? Hearing none, all those in favor signify by saying aye.
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 Those opposed by no, the ayes have it. The motion carries.
Item number 14 appears in docket number 2025-89E. This is a motion to dismiss filed by Dominion Energy South Carolina Incorporated and final disposition of this docket.
As to item number 14, is there a motion?
Chair Powers?
Commissioner Williams.
Thank you. Before I begin with this motion, I want to, Chair Powers, let you know and fellow commissioners know this is a really long motion, and I read through it numerous times to see if I could simplify it some, but it really needs to all be articulated. So with that in mind, as I go through it, you'll see there's an introductory comment, there's a summary of the complaint, there's a bit of legal history that my decision is kind of based on, and finally the motion that I bring for your consideration. On March 5th, 2025, complainant John Crane, a pro se litigant, filed this action against Dominion Energy South Carolina Incorporated. Mr. Crane alleges that Dominion Energy improperly altered the manner in which he receives an offset for solar production under Rate 5 and the Solar Choice Rider. On April 9th, 2025, Dominion filed an answer denying Mr. Crane's allegations, along with a motion to dismiss. The Commission heard oral arguments on Dominion's motion to dismiss on July 23rd, 2025. The Commission took the motion under advisement and proceeded with a hearing on the merits immediately following the oral arguments. At the hearing, Mr. Crane presented his testimony and other evidence. Likewise, Dominion presented its own witness. The evidence presented demonstrates that in 2023, Mr. Crane signed an interconnection agreement with Dominion and installed a rooftop solar system on his home. At all times, Mr. Crane has taken service under Rate 5 and the Solar Choice Rider. When Mr. Crane first took service, he was able to offset up to 100% of his energy usage against excess energy delivered to Dominion. No party disputes that at this time, Rate 5 and the Solar Choice Rider allowed for such offset and divided energy usage and delivery into two periods, on-peak and off-peak. For purposes of calculating the offset, on-peak usage could be offset by on-peak delivery, with off-peak usage offset by off-peak delivery. Collectively, on-peak and off-peak account for 24 hours or 100% of a day. Thus, if Mr. Crane delivered more energy than he consumed during the on and the off-peak periods, he could offset 100% of his energy usage. Next, in 2024, Dominion filed an application in docket number 2024-34-E, requesting authority to adjust and increase its retail electric rate schedules, tariffs, and terms and conditions, also known as the 2024 rate case. In the 2024 rate case, the Commission adopted and approved a settlement agreement that authorized Dominion to modify numerous rate schedules, including Rate 5. Dominion Energy neither requested nor did the Commission approve any modification to the Solar Choice Rider. As for Rate 5, in the 2024 rate case, the Commission approved the addition of a third billing period, super off-peak. The super off-peak period constitutes 4 hours per day from 1 a.m. to 5 a.m. year-round. Notably, any customer can take service from under Rate 5. It is not limited to those also taking service under the Solar Choice Rider. The updated Rate 5 became effective for service rendered on and after September 1st, 2024. Thereafter, Dominion Energy, citing the update to Rate 5, did not allow Mr. Crane to offset excess energy delivered to Dominion against the energy he used during the super off-peak period. In other words, Mr. Crane could only offset up to 20 hours per day of his usage. He would always receive a charge for any energy used during the 4 hours a day, now known as super off-peak period. Mr. Crane challenges Dominion Energy's application of the Solar Choice Rider and the updated Rate 5 to his account. Mr. Crane argues that the Solar Choice Rider guarantees him a minimum of 10 years, wherein he can offset up to 100% of his usage. Dominion Energy argues that the Solar Choice Rider incorporates the update to Rate 5 such that the new super off-peak is excluded from net energy metering. To evaluate this dispute, the Commission must first look to the origins of the Solar Choice Rider. In 2019, the General Assembly passed Act 62 and outlined the intent of the legislation, and I quote, "It is the intent of the General Assembly to build upon the successful deployment of solar generating capacity through Act 236 of 2014 to continue enabling market-driven private investment in distributed energy resources across the state by reducing regulatory and administrative burdens to customer installation and utilization of on-site distributed energy resources. Number 2, avoid disruption to the growing market for customer-scale distributed energy resources. And number 3, require the Commission to establish solar choice metering requirements that fairly allocate cost and benefits to eliminate any cost shift or subsidization associated with net metering to the greatest extent practicable." That's from South Carolina Code Annotated 58-40-20A. Act 62 required that the Commission establish a solar choice metering tariff for customer generators to go into effect for applications received after May 31st, 2021. South Carolina Code Annotated 58-40-20F1. The Act provided that the solar choice metering tariff shall include a methodology to compensate customer generators for the benefits provided by their generation to the power system, and provided considerations for the Commission to consider in determining the appropriate billing mechanism and energy measurement interval. South Carolina Code Annotated 50-40-20F3. Additionally, Act 62 required the Commission to establish a minimum guaranteed number of years to which solar choice metering customers are entitled pursuant to the Commission-approved energy measurement interval and other terms of their agreement with the electrical utility. South Carolina Code Annotated 58-40-20H. On May 29, 2021, the Commission entered Order Number 2021-391, Order establishing solar choice tariff for new customers beginning June 1st, 2021, in docket number 2020-229E. The Commission considered proposed tariffs submitted by the parties, including Dominion Energy South Carolina. Interpreting South Carolina Code Annotated Section 58-40-10C5, the Commission stated, Act 62 intends for rooftop solar customers to be able to invest in solar systems sized appropriately to be capable of offsetting all the customer's energy usage. The Commission concluded that it was appropriate to utilize time of use Rate 5 as an element of the solar choice tariff. At the time, Rate 5 only included on-peak and off-peak periods, which covered 24 hours a day, 365 days a year, and the Commission concluded that the customers could credit on-peak delivery against on-peak usage and off-peak against off-peak. Thus, customers could potentially offset 100% of their usage, consistent with the Commission's interpretation of Act 62 that rooftop solar customers have the potential to offset all their energy usage. In establishing the minimum guaranteed number of years to which solar choice metering customers are entitled pursuant to Commission-approved energy measurement interval and other terms of their agreement with the electrical utility, the Commission discussed the considerations underlying the different proposals. the Commission, discussing testimony offered by the joint interveners, stated in its order, consistent tariff structure and availability over a reasonable investment period are necessary for providing certainty to potential customer generators. Further, 10 years representing a reasonable investment period also represents the minimum number of years allowable for customers taking service under the new tariff to have access to the tariff. Thus, the Commission ultimately ordered that these residential and non-residential tariffs shall remain available to customer generators taking service pursuant to these tariffs on or after June 1st, 2021 for a minimum period of 10 years. Dominion Energy filed the residential solar choice tariff as a rider to the residential rate 5 solar choice for renewable energy facilities, referred to herein as Solar Choice Rider, in 2021, and it has not been modified since initially filed. Consistent with the Commission's order, the Solar Choice Rider refers only to on-peak and off-peak delivery and usage. It states, for any billing month during which excess energy exceeds the customer's usage in total, producing a net credit, the respective energy charges for the month shall be zero. Additionally, the Solar Choice Rider states, customer generators are eligible to remain on the rider for a minimum term of at least 10 years, or until such time as the customer elects to terminate service under the rider, whichever occurs first. In an overview of the South Carolina residential solar programs prepared by Dominion Energy and submitted as evidence in the hearing, Dominion Energy states that under Solar Choice, a customer can offset up to 100% of annual usage, 20 kilowatts maximum. Further, Dominion states that the term is 10 years from the date of interconnection. My motion is based on the following statutory elements, applicable tariffs and riders, as well as the Commission's prior orders. And these include the General Assembly passed Act 62 to encourage investment in solar. Act 62 required the Commission to establish a solar choice tariff. The Commission, interpreting Act 62, concluded that a customer must be allowed to offset all the customer's energy usage. The Commission acknowledged that the consistent tariff structure and availability over a reasonable investment period are necessary for providing certainty to potential customer generators, and set 10 years as the legislatively mandated period which solar choice metering customers are entitled pursuant to the Commission-approved energy measurement interval and other terms of their agreement with the electrical utility. The Solar Choice Rider states that for any billing month during which excess energy exceeds the customer's usage in total, producing a net credit, the respective energy charges for the billing month shall be zero. The Solar Choice Rider provides that customer generators are eligible to remain on the rider for a minimum term of at least 10 years. And the Solar Choice Rider does not reference super off-peak, only on-peak and off-peak. In addition, Dominion Energy's own overview of South Carolina residential solar programs as of the day before the hearing in this matter states that customers can offset up to 100% of annual usage, and that the term is 10 years from the date of interconnection. Considering all of this, I arrive at the following conclusion. Pursuant to Act 62, Commission Order Number 2021-391, and the terms of the Solar Choice Rider, Mr. Crane is entitled to offset up to 100% of his usage under the rate structure in effect at the time of interconnection for a minimum of 10 years from the date of interconnection. Based on the express legislative intent contained in Act 62, as well as the Commission's discussion in Order Number 2021-391, it's clear to me that the purpose of requiring a minimum guaranteed number of years a customer is entitled to the energy measurement interval and other terms of their agreement with the utility is to protect customers who make significant financial investments in rooftop solar. The General Assembly, along with the Commission, sought to prevent a situation where a customer made a significant investment with the expectation that he or she would be able to recoup the investment over a set period. only to have the terms of the deal grow more unfavorable over time. To prevent this, the General Assembly required a mandatory minimum number of years the customer would be protected. In this case, the Commission set the period as 10 years. Finally, I will address Dominion Energy's argument that the Commission approval of modifications to Rate 5 among numerous other rate schedules in the 2024 rate case allows for a reduction in the amount of energy Mr. Crane can offset under the Solar Choice Rider. First, it's important to note that Rate 5 is a standalone rate schedule in that it is not exclusively tied to the Solar Choice Rider. In other words, a customer who has no solar system can take service under Rate 5. As Dominion Energy correctly points out, the Solar Choice Rider does provide that all provisions of Rate 5, including but not limited to determination of on and off peak hours, apply to service supplied under this rider. Likewise, it states the on-peak and off-peak periods shall be defined in Rate 5, time of use, residential service. This language does nothing more than implement the Commission's directive in Order Number 2021-391 that the residential solar choice tariff must include a requirement to take service under Rate 5. Nothing in the Commission's order suggests that the fundamental structure of the solar choice tariff can be altered through a modification to Rate 5, such as reducing its applicability to certain hours in a day. Indeed, Act 62 includes specific considerations for the Commission in establishing any successor solar choice metering tariffs and in approving any future modifications. South Carolina Code Annotated 58-40-20F2. To the extent that a modification to Rate 5 in the rate case could alter the terms of the Solar Choice Rider, that still leaves unaddressed the issue of the 10-year guarantee. In this case, Mr. Crane was entitled to a 10-year guarantee to which he was entitled pursuant to the Commission-approved energy measurement interval and other terms of his agreement with the electrical utility. At the time of interconnection, Mr. Crane was entitled to offset 100% of his usage, and he was entitled to such offset for a minimum of 10 years. For these reasons, I move that the Commission deny Dominion Energy's motion to dismiss. I further move that the Commission find that Mr. Crane is entitled to the rate structure in effect at the time of the interconnection for a minimum of 10 years. Included in this rate structure is the ability to offset up to 100% of his energy usage. I note that as used in this matter, the phrase rate structure does not include the per kilowatt energy charge included in Rate 5. Mr. Crane concedes, and the Commission agrees, that the updates to the charges within Rate 5 apply to customers taking service under Rate 5 and the Solar Choice Rider. Finally, I move that the Commission enter an order that fully sets forth its findings and conclusions. I so move, and I thank everybody for their patience.
Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Williams.
I vote aye.
Commissioner Belser,
I vote no.
Commissioner Caston,
Aye.
Commissioner Britt,
No.
and I vote no. The motion fails.
Mr. Chairman,
Commissioner Britt,
I'd like to make a motion.
certainly.
On March 5th, 2025, complainant John Crane filed this action against Dominion Energy South Carolina, Inc. Mr. Crane alleges that Dominion Energy South Carolina improperly altered the manner in which he receives an offset for solar production under Rate 5 in the Solar Choice Rider. On April 9th, 2025, Dominion Energy South Carolina filed an answer denying Mr. Crane's allegations, along with a motion to dismiss. The Commission heard oral arguments on Dominion Energy South Carolina's motion to dismiss on July 23rd, 2025. The Commission took the motion under advisement and proceeded with a hearing on the merits immediately following the oral arguments. At the hearing, Mr. Crane presented his testimony and other evidence. Likewise, Dominion Energy South Carolina presented its own witness. Based on the evidence in the record, I move that the Commission find that Mr. Crane takes service under Rate 5 and the Solar Choice Rider in order number 2024-610 entered into docket number 2024-34-E The commission approved the creation of a super off-peak period in Rate 5. The Solar Choice Rider specifically incorporates all provisions of Rate 5, and at all times relevant to Mr. Crane's complaint, Dominion Energy South Carolina properly billed Mr. Crane in accordance with the commission-approved Rate 5 as incorporated in the Solar Choice Rider. I further move that the commission find and conclude that Dominion Energy South Carolina did not violate any statute, rule, regulation, or order administered or issued by the commission. Therefore, I move that the commission dismiss the complaint with prejudice, and because my motion fully resolves this matter, I move that the commission find and conclude that Dominion Energy South Carolina's motion to dismiss is rendered moot. Finally, I move that the commission enter an order that fully sets forth its findings and conclusions. I so move.
Thank you, Commissioner Brett. Having heard this motion, is any further discussion?
Chair Powers.
Commissioner Caston.
Just an opinion. I don't think when the Rate 5 and the other rates that were approved, I'm not of the opinion that any party considered this aspect of it. I don't know that, but I don't think anyone did. So I don't think there was any intent to do anything wrong. But I do agree with Commissioner Williams' motion relative to the solar choice tariff in the way, it hasn't been changed. And I come to that conclusion, that all does mean all. 24 hours means 24 hours. And I struggle to understand how a 10-year agreement can be of any value if the basis of it, the time frame, the interval, can be changed absent the commission changing the solar choice tariff, which we've not been requested to do. That said, I appreciate and understand the opposing opinion. So I guess that's all I have to say about that. Thank you.
Thank you, Commissioner Caston. Any further discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Brett.
Aye.
Commissioner Carolyn Williams.
No.
Commissioner Belser.
Aye.
Commissioner Caston.
No.
And I vote aye. The motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda. In Part A, there is one application for a new Class C certificate. Item A1 is in docket number 2025-251T, which is the application of We Care 2 Home Care, LLC, for a Class C non-emergency certificate.
As to item A1, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the commission approve the application of We Care 2 Home Care LLC for a Class C non-emergency certificate. The Class C non-emergency certificate grants to We Care 2 LLC the authority to provide motor carrier services as follows: between points and places in the state of South Carolina, restricted to 7 passengers, including the driver. I move the commission find that We Care 2 Home Care LLC is fit, willing, and able to provide the service to the public as requested. I move the commission find a certificate shall be issued by the Office of Regulatory Staff to We Care 2 Home Care LLC upon compliance with South Carolina Code annotated section 58-23-10 et sec. As amended, and the applicable regulations for motor carriers, South Carolina Code Annotated Regs, Volume 10, Year 2012, as amended, and the requirements listed in Exhibit A attached to this directive.
Thank you, Commissioner Williams. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part B of the transportation agenda, there is one request to cancel a certificate. Item B1 is in docket number 2023-25T, which is a request from Sky 7 LLC to cancel Class E household goods certificate number 9906.
As to item B1, is there a motion?
Chair Powers,
Commissioner Caston.
I move that the Commission grant the request of Sky 7 LLC to cancel its Class E household goods certificate number 9906.
Thank you, Commissioner Caston. Having heard the motion, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part C of the transportation agenda, there is one request to reinstate a certificate. Item
As to item
C1.
C, I'm sorry. Go ahead.
is in docket number 1997-35T. This is a request from Winston Elaine to reinstate Class C taxi certificate number 6463.
As to item C1, is there a motion?
Mr. Chairman,
Commissioner Brett.
I move that the Commission grant the request for reinstatement in agenda item number C1 as identified by Mr. Scarborough. A directive order will be issued in the docket detailing the timeline for coming into compliance with the order.
Thank you, Commissioner Brett. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part D of the transportation agenda, there is one request for an extension of time. Item B1 is in docket number 2025-137T. This is a request from Open Hearts Transportation LLC for a 3-month extension of time to comply with Commission rules and regulations.
As to item D1, is there a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the Commission grant the request of Open Hearts Transportation LLC for an extension of time until December 11th, 2025 to comply with Commission rules and regulations by completing the certification process pursuant to paragraph 5 of Exhibit A to order number 2025-289, granting the authority to provide motor carrier services, which was issued on May 15th, 2025. The certification process requirements are that the applicant must A, file with the Office of Regulatory Staff proof of appropriate insurance, and B, also tender payment of license fees as well as provide such other information required by law to the Office of Regulatory Staff.
Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, any further discussion? Hearing none, we'll proceed to a roll call. We'll proceed to a voice vote. All those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Mr. Chairman and Commissioners, this concludes all business noticed before the Commission today.
Thank you, Mr. Scarborough, and all who joined us. Have a good rest of your week and weekend. We are adjourned.